week, or $47,476 a year. Now, the duties tests haven't changed, so you still have to meet all the duties tests for the category you're in, but now you're going to have to be paid $913 a week. There is a provision called the highly compensated employees, where if you make a certain high amount in salary, they relax the duties tests a lot. I'm not sure how many shops are going to pay their guys $134,004 a year on a salary basis, but there will be some. And at that level, you still have to meet a little bit of the duties tests, but not much, and we won't go into any great detail. Now, there is there are two very new and unique provisions to the salary basis test. Number one is they're going to index it, and they're going to raise it every 3 years, or, well, if the basis upon which they're indexing it goes down, it might go down, but don't count on that. So starting in August of 2019, effective January 1st of 2020, there'll probably be, almost certainly be, a new salary test. So having learned it once, you got to pay attention to it, and every 3 years they're going to announce something like 120 days in advance, they're going to announce what the new salary test is going to be. And then the other thing they did was, and this is the first time they've done it in the whole almost 80 years of the exemption, they are going to allow a small portion of that $913 a week to be met by virtue of a commission or a non-discretionary bonus. Now, that's only 10%. So essentially it works out that you could pay as low as $821.70 a week, and then over some longer period, but no longer than a calendar quarter, you could have the person be given bonuses or commissions, and then at the end of the calendar quarter, you got one payday to look back and make sure that they earned 13 weeks times the difference between 821.70 and 913. In other words, you get to true it up. And at the end of one pay period after the end of the calendar quarter, if they fell short, you could pay some extra, and that would bring them up to the 913 a week times 13 weeks in the quarter. So at only 10%, I don't know how helpful that is, but it is a unique and brand new feature. So that's what we're talking about. Now, keep in mind that the salary basis of payment requirement means that the employee, generally speaking, is paid his or her full salary for any week in which they do any work at all. If things are slow and you send them home, they still make $913 that week. But there's some pretty big exceptions. You don't have to pay overtime. You don't have to pay for personal absences of a full day or more. And if you've got a bona fide sick leave plan, you don't have to pay exempt employees when they've used up their sick leave and then miss a full day at a time. But you've always got to pay exempt employees for partial days. So if I show up on Friday morning, work a couple of hours, and suddenly realize that, you know what, work makes me tired, I think I'll go home, you got to pay me. Of course, you could fire me, but you have to pay me if I do any work on a day and take the rest of the day off for personal reasons. So in a nutshell, that's what the Department of Labor is doing. Now, what should you, as shop owners or shop managers, be doing? Well, the first thing, obviously, is you're going to have to make a decision. You're going to have to look at the people that you've got in your shop whom you classify as salaried exempt, and if they are below the $47,476 level, then you've got to decide either you're going to convert them to non-exempt and pay them hourly and pay them overtime, or you're going to give them a raise. Now, clearly, if they're already at 47 or more, then you're fine. You don't have to make any change. But step number one is identify those people whom you wish to be exempt, who are making less than the 47,476, and decide whether or not you want to give them a raise or convert them to non-exempt. All right. So if you decide you want to convert somebody to hourly, you don't have to divide their current salary by 40. If they were working a bunch of overtime already, if you did that, their total income would increase dramatically. So you can always set their hourly rate so that if they work the number of hours that you typically have them work, they'll make roughly the same amount that they're making now. So you can set their hourly rate anywhere from minimum wage up to correspond with the amount of money you've got budgeted for the labor cost in that particular situation. All right. If a manager, this is a good opportunity, by the way, for a shop to look at all of its management and administrative personnel and make any changes. Let's suppose that you have some employees whom you've been paying salary to, thinking they were exempt. Now everybody's heard that this change is coming up. Well, what if you're wrong? What if you have made some mistakes and misclassified some of these folks and they don't really qualify for exemption? This would be a terrific time to fix that without having to admit you'd been doing it wrong. So let's say I got a shop supervisor, and again, he spends 99% of his time with a wrench in his hand. He doesn't qualify for exemption, but I've been paying him salary only anyway. This would be a terrific time to look at that guy and say, you know what, with this new reg coming up, Charlie, we're gonna convert you to an hourly rate. You don't have to go to him and say, gee, Charlie, we've been paying you in violation of federal law for the last 2 or 3 years. You know, that's maybe not the best way to approach it. So this change gives you a certain amount of cover. It gives you the opportunity to audit your exempt classification system and make any changes that you might need to make. I'm going to mention one other thing that's not on the agenda, but I always mention it when I talk to ASA people, and that's this. For your non-salaried, non-exempt people, ASA members are at a tremendous disadvantage in competing with dealerships. And the reason for that is dealerships have a complete overtime exemption for all salesmen, partsmen, and mechanics. You don't have that blanket exemption. But what you do have is the possibility of an exemption for commissioned employees. So if a shop is retail and it pays its employees primarily by commission, and they're able to average more than 1.5 times the minimum wage, they are exempt from overtime. Now, there's a lot of detail to that exemption. It's called FLSA Section 7I. But what it does is, under the FLSA, under the federal law, it allows you to pay flat rate hours, booked hours, shop hours, whatever you want to call them, to your technicians and make them exempt from overtime if you meet all of the requirements. Now, I don't have time to go into all those requirements, but I definitely wanted to bring that up. I have written articles on that exemption in the past, and it's not only the Department of Labor treats flat rate hours as commission, but we've got at least 2 Court of Appeals decisions, one out of the 11th and one out of the 7th Circuit, that uphold that. So we're in pretty good shape. Again, that's a digression from the proposed topic today, but it's something that I just wanted to mention, and it's something that you probably need to look into, and it may give you a certain amount of comfort. The last thing I'll do is, like every lawyer, I'll cover my ass. Nothing I'm saying here is to be construed as legal advice. It's general information. And also, we have talked only about federal law. Remember that states are free to impose stricter standards, and some states, I'm not aware of any states that require more than 913 a week, but it may very well happen. You know, in places like California, they're always trying to be out ahead of the feds. When you have an employment compensation question, not only familiarize yourself with the federal law that we're talking about today, but you ought to familiarize yourself with the state law in your jurisdiction so that you don't trip over the state law. Basically, that's all I've got, and obviously when we get to the question session, I'm more than happy to answer any of your questions.
Brian, thanks so much, and we will have questions for Brian. Go ahead and start thinking about those questions, understand any questions you have. Next up, we have Daryl Amberson, President of Operations, Lemaitrie's Collision, and past Chairman of ASA, and Daryl's going to speak in terms of shop owner's viewpoint from a collision perspective. Good afternoon, Daryl.
Thank you, Bob. Thank you. Just to start out with, I had the opportunity a few years ago, before I worked for Lemaitrie's, to experience a Department of Labor audit. And what Brian is saying is very true. One of the first things they coached me on was that Department of Labor law was written during the Great Depression and took a very obvious slant towards discouraging companies from having overtime, thus the idea of causing them to hire more people and reduce unemployment. And I found that to be very relevant because complying with these classifications is quite a challenge. On the collision side, one of the most obvious positions is the most noteworthy probably are the estimators, which many shops do classify as exempt. The company I did at that time as well. One of the things that we learned was that there's all sorts of criteria for that, as Brian explained. One of them was even a term that they use is that the individual deals with matters of significance. To me, lunch is significant, but they didn't really care for that interpretation. They had their own interpretation. There's others that include a right to hire and fire, negotiate on behalf of the company, things like that. Technicians, if they're paid some incentive, can be exempt. And of course, technically, I guess you could pay anybody in any kind of pay plan, but you have to be prepared to calculate the overtime when they do work that, and in a salary or an incentive, or even worse yet, an incentive type situation, it becomes exceedingly complicated and perhaps more expensive than you anticipated. At my experience there, one of the things that we learned was that of the importance of having people punch in and out. You have to have very complete records, otherwise you jeopardize yourself to be subject to the interpretation of the individual. If you don't have time clock records, they may go to that individual and say, you tell us how many hours you worked over the last X number of months, and as a business you may end up paying overtime for those hours over 40 hours a week. Another thing we learned about was that for larger companies, there can be kind of a class action type of a suit that can take place, whereas if you have multiple people in the same category, and if an attorney or someone considers them classified wrong, they can potentially reach out to other people in that same position. I know this has happened with some consolidators in the past with, I believe, estimators or perhaps customer service reps, where they say, you may be eligible to get some additional overtime payment, and we are here to help you. And as a business, you may end up being faced with a class action type of a scenario where you could see become penalized and pay a lot of overtime for lots of people. So bottom line is, the importance of this is the understanding the regulation. Another thing I learned was that when my audit was all done, and I'm talking to the auditor, basically we came through pretty clean and had to make a few adjustments, pay a few people some extra overtime we didn't expect. And I told the auditor that if nothing else, now we know where we stand in terms of who can be classified as exempt and who not. And his response was to say, no, whoa, don't consider that, because the next auditor may interpret the regulation a little differently and your experience could be a little different. So bottom line, it emphasizes the importance of understanding the regulation and erring on the side of caution. And so of course now with this new regulation, it adds some additional challenges because the definition has changed, and now the definition will even change every few years, as they're going to update the salary threshold every 3 years. So my message to those listening is, as a collision repair, pay attention, get some professional advice, err on the side of caution, and have everybody punch in and out. Bob, and that's my initial spiel.
Thanks so much, Daryl. Next up is Ed Cushman, a mechanical shop owner from Spokane, Washington, and also ASA board member. Ed, good afternoon.
Great, thank you, and good afternoon, Bob. I appreciate the opportunity. Great advice that Brian and Daryl have shared thus far, and I want to expound on that a bit. I also have been subject to a labor and industry wage audit and it's very interesting. Daryl gave some great things, and from that, I'll start there. And what I'd recommend all of you do in preparation for these new rules is review your overtime policies, making certain that in your employee manual you address overtime. As to the point, specifically ours states that the only overtime that is acceptable is that if it's authorized in writing by your immediate supervisor. It's a good control point. And then from that, Daryl alluded to it, review your time tracking systems. It can be a wonderful opportunity to step back, take a look at your employees that are spending more than 40 hours a week and perhaps not being compensated for it, and you can rearrange those schedules. From the mechanical side of it specifically, we all pretty much face the same categories of which many of us for years have considered to be exempt, including myself, that of a general manager, service advisors, and parts managers, and commission technicians, or flat rate, if you will. I'm going to contradict Brian very professionally and just on the surface based on information that I've learned in the last couple of weeks about technicians. But I think when you go back to the executive exemptions and even the administration exemptions, which are very ambiguous as far as who might fall into that, and I suspect you all might be like me when you're running a small business. You continue to ask the questions until you get the answer you want, and sometimes we ask too many questions directed toward trying to get us to the point to say, "Gee, I knew that was exempt. I just never asked the right person." Well, in preparation for this, I'd ask a lot of questions from my own state, and basically with the new ruling, it's the Department of Labor and Industry has become acutely aware of classifications, and in one article that I read actually alludes to the fact that 50% of all of our employees are classified improperly. And so my first preparation of caution would be look at those classifications and make sure they actually apply. And predominantly in the mechanical arena, service advisors are ones that I always thought with the base plus commission, they could work 12 hours a day and we were covered. According to literature, now this is in the state of Washington, and so I'd all encourage you to check with your local Department of Labor, whoever that may be, for clarification. And as both Brian and Daryl have alluded to, these rules are very open to the site interpretation of the person that's reviewing them. But in the state of Washington, service advisors, even though they're commission-based, are no longer exempt from the overtime ruling from SLA. The flat rate technicians, according to the director of the Department of Labor and Industries in the state of Washington, says we can pay them flat rate, but if they work overtime, we have to average the amount they're paid by the hour and pay time and a half of that amount for any overtime that they're working. I know that contradicts Brian's statement and the Court of Appeals, and in Washington State, 5 years ago, that was not the case. I have a written document that states it was acceptable to exempt them as commission-based employees. So I think with all this in the air, and there's a lot of conversations about it, I just really encourage all of you on this call to talk to the authorities in your state that are administrating the overtime laws and verify who is exempt and who isn't. But to back up, and the most important thing you can do is prepare your business policies and procedures with reviewing those, get it documented who's eligible for overtime, and the tracking systems that you have, making sure that you're keeping very accurate time records. So you don't end up with, I do know from experience, as Daryl does, if you don't have time records, the Department of Labor is always going to side with the employee, just obviously. So that's what I would say, and there's a lot of information. It's all great information, and I think if we just pay attention to it, talk to your local authorities, and structure your pay systems accordingly, will be great.
Hey Ed, this is Brian. Let me just real briefly follow up before we get to the Q&A. Follow up on a couple of things that you just said. I said you got to check with the state as well as the feds, and you just got a perfect example of that. You can't in a state like Texas, where I'm from. There is no state law for all practical purposes. Texas is a very conservative, pro-employer state. You get to so in Texas, you follow the federal standard. You go to California, and California is notoriously tougher than the feds. And so you could be in perfect compliance with federal law in California and get hammered by the state. The commission exemption, for example, that I talked about, here in Texas, you know, everybody goes crazy with it. It's just great. You go to California or Ed's saying Washington, and it's not going to apply to certain people. In fact, California, it's not going to apply to anybody in an ASA shop. So again, it's not enough just to be familiar with the federal law. If you're in a pro-employee state like California or New York or New Jersey or one of those places, you know, you may well find that the state has a tougher rule than the feds, and you got to know both. Now, then let me also pitch in with another standard attorney thing in addition to CYA, which is to recommend to you, and it's not just, you know, it's not just because this is how I make my living. The best way to find out about this stuff is to find a qualified employment lawyer in your area and get a little legal advice. You know, you can pay somebody a couple of $100, $300, $400, $500, $1,000 in legal fees, and save yourself many, many times that in money and in hassle. So get some good advice. And structure your pay system accordingly. The other thing Ed said about not having time records, boy, that's for sure. As I've always told people, if you don't have time records, you are at the mercy of your least honest employee.
Thank you, Brian. Well, we've got our first question from Gary from Florida, and here we go. This is for Brian. Our service advisor is on an annual salary of $32,000 a year plus commission on sales. Could I be impacted by this if, in that position, if commissions or sales could run as high as enough for $25,000 to $35,000 commission on top of the salary?
Okay, there's a couple of questions that are packed into that, and let me try to address them in order. First, you have the question as to whether or not a service advisor can even be considered exempt at any salary level. And while it's true that titles alone don't determine this, and what the service advisor at my shop does could be very different than what the service advisor at your shop does, and maybe come up with a different answer. I will say that in general, the Department of Labor takes the position that service advisors are not going to qualify for exemption because of their duties. They're not doing supervision, so they can't qualify as executive, and they're not doing high-level administrative work, making decisions in matters of significance that involve the exercise of discretion and independent judgment, to echo what we heard earlier. So I would say that right now, anybody that's paying a service advisor a salary, that's probably a mistake. Now, having said that, let's talk about, so whether you're paying them $455 a week under this rule or $913 starting in December, I still don't think that you'd get through a Department of Labor investigation without that being challenged. Now, with regard to the commission portion, these are two different exemptions, and I can't emphasize enough how important that is. The white-collar exemption for salaried employees, that's the one where you have to meet the duties tests and you have to pay a salary, which goes to $913 in December. For other employees, the potential for this totally different exemption, 7I exemption, exists. And so in Florida, if the employee in question is working for a retail shop, meaning 75% or more of its gross revenue is derived from retail transactions. So that's the first element of 7I. The second element of 7I is the person has to be averaging at least 1.5 times minimum wage. Now, federal minimum is 7.25, so 1.5 times that is 1088. Florida minimum is a little higher. But most service writers are going to be paid enough that when you divide their total compensation by the total hours they work in any given week, they're always going to average more than 1.5 times minimum wage. So in the Florida case, the third requirement is the key. The third requirement says the employee's got to be paid primarily by commission, meaning over 50% of his income has to be derived from commission, not from salary or not from hourly rate or anything else. So if I had a service advisor who I paid, let's say I paid him 10% of the estimates he wrote, or all right, just make up some numbers. I pay him 10% of the estimates he writes. He writes $500,000 worth of estimates. So he's going to make $50,000 that particular year. Okay, that's great. If I paid him $35,000 guaranteed salary and he got the other 15 from his commission, that doesn't go so good because that's less than half of his money from commission. So what I would do is either set the commission rate high enough so that he's going to make more from his commissions than his base, or even better, consider that he's 100% commission but pay him a draw. So in that example, if I paid that guy 10% of the estimates that he wrote, and he wrote $50,000, or he wrote $500,000, so he got $50,000 in commissions. If I gave him a draw of say $400 or $800 a week, so that he'd make about $42,000 in draw, he still made $50,000 in commissions because draw against commission is commission. So the answer to that question is that under the white-collar exemption, that service advisor is almost certainly not going to qualify for exemption. But under 7I, if you make sure he's making more from commissions, he probably would. And let me say that following up on that issue of state law, in Florida, there is an 11th Circuit case out of Florida called Kleindienst, where the 7th Circuit or the 11th Circuit upheld 7I for technicians, and it's in Florida. And the expert witness in that case was yours truly, so I'm particularly familiar with that case. But again, what I just said in Florida may not be true in Washington State or in California.
Thank you, Brian. Brian, we're getting a lot of questions about that are all very similar. That in talking to a professional in my state regarding this issue, am I really looking at my accountant, or what type of attorney would I be looking for? What kind of practice area for a lawyer if I want to look at restructuring or just have some questions, more specific questions?
Well, accountants know a heck of a lot about a lot of things that I don't know anything about, but most accountants are not likely to be familiar with the ins and outs of the wage and hour laws. So, without in any way trying to denigrate accountants, I would go to a lawyer. A lot of states have specific categories of where, like you're board certified in employment law. That's a good guidance, but if they don't have it, the point is you go looking for somebody who practices regularly in employment law on the management side, on defense side, and who is familiar with the Fair Labor Standards Act. And that's really where you should get your advice. The problem with getting your advice from any of the enforcement agencies is they are look, public service is a grab bag. When I worked for the Department of Labor, I thought I was pretty damn good, but not everybody was quite as knowledgeable as I was, he says modestly. And, you're kind of at the mercy of whoever picks up the phone. So I would, I think finding a qualified employment defense lawyer in your area who's experienced in Fair Labor Standards Act is the way to go.
Hey, Bob, it's Ed, and I agree with Brian.
Go ahead, Ed.
Completely. I'm sorry. I was just going to say it, and that's a very valid point, and that's the reason my questions, we always want to ask the right person the right question. I don't know how many callers are on from Washington State, but if you like, I can give you the ASA endorsed labor and wage attorney that we use for all matters, and where a lot of my research was done through. It's Rod Steppen, and his phone number is area code 253-863-2525. Very knowledgeable with labor law in Washington State.
Thank you, Ed. We've got another question coming in from Cliff from Winston-Salem. Can a manager trainee be exempt? And this is for Brian. Can a manager trainee be exempt if they have no direct reports and make no hardcore decisions for my business that affect the company, but are training to do so? So, question on manager trainees.
The regulation in question specifically says that trainees are not exempt. They have to actually be doing as their primary duty the work in the specific category. So manager trainee is not exempt until he or she is actually being a manager.
Thank you, Brian. Brian, from Amy in Maine, please explain, if I pay a flat rate, how am I impacted in my business?
All right, well, this change that we're talking about, the change in the salary test, does not affect flat rate technicians at all. This affects only those employees whom you believe to qualify for white-collar salaried exempt status: executives, administrative employees, professional employees, outside salespeople. The rules for techs who are paid on flat rate are the same as they have been, and to my knowledge, no change is contemplated, meaning that they can be exempt under an entirely different exemption. I emphasize that again, the FLSA Section 7I exemption, which says the Department of Labor clearly says that flat rate payment is a commission, and so if you're a commission tech and you make more than half your income from commission and meet the other requirements, you can be exempt from overtime. I'm not familiar with the state law in Maine, so I would encourage you to consult with somebody in Maine who knows their state law. But under the federal law, your techs could continue to be exempt if they've met the requirements for the 7I exemption.
Thank you. All right, Brian, this is from Steve in Texas. Okay, so a Texas shop owner. Does a 100% commission technician in Texas need to punch in and out? They all make $65,000 a year.
All right, they're probably exempt, on the basis that we've talked about as 7I, but they still have to punch a time clock. It's required by regulation, and also that's the way that you are able to determine if they were able to average 1.5 minimum wage on a work week to work week basis. So if a guy makes $700 in commissions and he works 50 hours, well, pretty clearly 700 divided by 50 is more than 1.5 times minimum wage. But let's say he had a bad week and he only made $500 in commissions and he worked 50 hours. Now he's only averaged $10 an hour, and for that week he could lose the exemption. So in that week, you'd want to, advance him some commission or boost him in some way, pay him another 88 cents an hour so that his average for that week would now be 1088 and he'd qualify for the overtime exemption. But yes, you got to keep a record of hours, and not just shop hours. You got to keep a record of clock hours, what people actually work.
Talk to a lawyer. Accountant's not good enough.
Okay.
Talk to
thanks, Brian.
To a lawyer that specializes in labor and wage and salary administration.
Brian, if people can mute their phone real quick.
We are at risk if we get
okay, I'd like to go to another question. Does that same rule apply for, or guidance apply, Brian, to office workers?
In most cases, the answer is yes. Some office workers might qualify for the administrative exemption, but keep in mind that to qualify for administrative, it's not enough simply to be making decisions. It's not enough to be doing bookkeeping, etc. You've got to be making decisions in what DOL calls matters of significance, and those decisions have to involve the exercise of discretion and independent judgment. What it means basically is if your office manager's doing payroll and payables and receivables and bank deposits and stuff like that, he or she's not exempt. You got to have somebody that's a high-level decision-making staff employee, an HR director, a safety director, a purchasing agent. People like that can qualify, but your run-of-the-mill secretarial, clerical types are not going to qualify.
Are there any other questions? Please type them in and send them to us. Ed or Daryl, do you have any closing comments?
Brian, I have a question for you. Sometimes human resource companies offer some free advice and service that may not necessarily include an attorney. What do you think of that?
Well, I don't want to disparage anybody. I was in consulting for a while before after I left the government, I went into private consulting and went to night law school. And so between the time I left the government and the time I got my law degree, I was certainly out there giving a certain amount of advice, and I wasn't a lawyer. In general, I would discourage people from getting legal advice from people who aren't capable of giving legal advice. Now, probably a lot of those folks from their own experience and intelligence and study know what they're talking about, but you can't really be sure. And if it's an important issue that if you're wrong about could cost your company a lot of money, I think you're better off going to a lawyer. And I know, yeah, everybody always says, well, lawyers say that so they can drum up more business. Well, hell yeah, we do, but also it happens to be true.
Thank you.
Great. Go ahead, Bob. This is Ed. And actually, there's one thing that didn't come up into this. Thank you. There was one question that didn't come up in the discussion that I wish would have, and so I'm going to ask Brian this because I think it's a very ambiguous exempt category, and that is the one of administrative exemptions. Brian, could you give some clarifications on that rule exemption?
Yeah, I just talked about that a little bit, but the exemption for administrative employees, I mean, you turn to the regulation, and it's just as ambiguous as you said it is. They have to have, their primary duty must be office or non-manual work directly related to the management policies or general business operations of the employer or the employer's customers. It must include making decisions in matters of significance, some of which involve the exercise of discretion and independent judgment. All right, that's pretty vague. What it amounts to is this. People who simply follow established policies and procedures are not going to be held to be exempt because they're not going to be exercising discretion and judgment. So my office manager does our accounts payable and accounts receivable. And a bill comes in, she gets approval from the boss to pay it, but then she goes through the mechanics of actually seeing that the check is issued, that the proper entries are made into the bookkeeping system, and the invoice is marked paid, etc. She's followed policies and procedures. Now, if she made a mistake, it could cause the company some problems. I mean, I'm not saying her work is unimportant, but that decision is considered to be a routine following policies and procedures, not exempt. Contrast that with a purchasing agent who actually has latitude to negotiate on the part of the company. Well, so let's say that we got 20 stores and I'm buying certain parts for our stores, and I negotiate with the supplier to try to get the best price. Since I'm buying in bulk, I got the best price. I negotiate for delivery times. I negotiate on their return policy. And let's say the other thing I do is I'm the one that decides in the company how much we're going to keep in stock. I mean, obviously, the more widgets you have on the shelf, the more money you got tied up with inventory. But at the same time, if a customer brings his car in and needs a new widget and you don't have one, you got to order it, and it's going to take a few days to get in, you got an upset customer. So those are the kinds of decisions. How much inventory do we keep on hand? What's the best price we can get? Can we negotiate different terms? That's considered discretion and judgment. So keeping the books is not discretionary, and that administrative employee is not exempt. A true purchasing agent with authority to negotiate on behalf of the company is considered to be an exempt administrative employee. Does that help?
It does. Thank you.
Okay.
All right. The next, we got another question here from Jason from Lansing, home of the Michigan State Spartans. There ever be a chance that independent shops could get the same type of overtime exemption applied to us as new car dealers get? Brian.
Well, all right. Well, let me first respond. Hook 'em horns. But the answer is you're not going to get a new exemption written into the Fair Labor Standards Act without a massive, sustained lobbying program. So the national organization would have to try to lobby Congress and see if that exemption would go through. Lord knows that's above my pay grade. I've never tried to get a federal law amended, but that's the kind of thing that's not left up to the Department of Labor. Something that a lot of people don't understand is what can be done by regulation by an agency versus what has to be done by statute. The salary test can be done by regulation. So the Bush administration raised it from $250 to $455 back in 2004. The Obama administration is now raising it from $455 to $913, effective December 1st this year. That can be done by regulation. But certain things can only be done by statute. For example, minimum wage. Minimum wage hadn't gone up since 2009. The Department of Labor cannot increase the minimum wage. They can ask for it, which they've done, but unless Congress goes along with it, the minimum wage is going to stay right where it is. So the existence of an exemption from overtime, like you're asking about, is something that's by statute, and so Congress would have to change the law.
Thank you, Brian. And from Tess, Brian, are there really any differences between how the collision industry will be impacted as compared to the mechanical repair industry and how they're impacted?
Not really. I have been given advice to both mechanical and collision shops for many, many years, and in the way that this particular law affects them, there's not any real substantive difference.
Okay. We've got from Liz Ann, do we need to keep time cards for exempt and salaried employees?
All right. The answer is no. You do not need to keep time cards for truly exempt employees under the white-collar exemption. So if you've got someone who genuinely qualifies both duties and salary to be exempt as an executive, let's say, a general manager who runs an entire shop, supervises a dozen people, gets paid, $1,500 a week, meets all the requirements. You don't have any obligation to keep a time record on that person. Now, some companies choose to do so, and you're permitted to do that. Some still like to have their managers clock in and out because they want to be sure there's coverage, maybe for workers' comp reasons, maybe for liability reasons. They just want to know whether the person is there or not. Other companies just want them to record that they're there that day or that they're off on vacation or whatever, and many companies don't require any kind of record at all for exempt employees. Now, for employees who you would be testing for the other exemption that I mentioned, 7I, yes, you must keep time records on those people. But for the salaried exempt white-collar employees, you may require it if you wish, and it doesn't change their exempt status, but you are not required to.
Thank you, Brian. I want to thank everyone for their participation today. And a special shout out to our presenters, Brian Farrington, Daryl Lamberson, and Ed Cushman. And the association really appreciates your contribution today. It's been very helpful for our folks, and look forward to a continued relationship. For ASA members, you can reach Brian for a 1-hour free wage and hour consultation. This number should be on the screen now. Again, thanks all of you very much, and I hope you have a great day.